Good afternoon everyone and welcome to this webinar. I'm Roger Leese, I'm a litigation partner at Clifford Chance.
And I'm Sarah Garvey in the litigation department at Allen & Overy.
This afternoon we're hoping to cover three subjects, as you can see on the slide here. The Brussels I regulation recast, unilateral options to litigate or indeed to arbitrate, and also the regulation for European account preservation orders. Okay, so we'll start with Brussels I regulation recast. This replaces the previous regulation and will apply to all cases that are instituted on or after 10th January 2015. What quite is meant by instituted has not been defined, but I suppose started would be at least a good place to start in considering this. Because of that, of course, there's going to be a very long run-off period here. Because cases instituted before then will still have applied to them the old regulation. It also applies to Denmark, who've opted into this particular provision, but perhaps quite importantly won't apply to the countries of the Lugano Convention, namely Switzerland and Norway. So the basic structure is the same as the old Brussels I. The starting point is still that persons must be sued in the jurisdictions in their home state, subject to exceptions, and those exceptions can relate to special jurisdiction in relation to contractual obligations or torts, or exclusive jurisdiction in relation to certain things like in rare immovable property, where a company is constituted, and so on and so forth, as before. And then also still in dealing with suing people or persons domiciled outside the EU, that's governed by the local law, subject to exceptions. So as I said, we're going to concentrate though on the areas where there have been changes or the principal changes, and we've listed those here: jurisdiction clauses, lis alibi pendens, forum non-conveniens and arbitration, and we'll also be dealing with, in brief, with enforcement as well.
So we've had two broadly helpful revisions to the Brussels regulation in the recast. First, in relation to jurisdiction clauses, broadening their scope, and secondly, in relation to the lis alibi pendens rules and attacking the torpedo. The third change is perhaps more controversial, and this relates to some new rules that are introduced for the first time, giving member state courts discretion to stay their proceedings where there are proceedings already on foot in a third state, so this means a non-member state, a third state court.
I'll next deal with briefly with recognition and enforcement, and then arbitration. On recognition and enforcement, as we say here, essentially the recast regulation has simplified matters. So all that's now needed in order to enforce in another member state a judgment that's been obtained is a copy of the judgment and a certificate. And although the certificate is quite long, it's also quite simple. There's no need any longer for a declaration of enforceability, known as an exequatur. So now we'll go on to our second topic for today, which is unilateral options to litigate, which I'll deal with. So, first of all, what are they? Well, I did mention them a little bit before when we could call them, one-way clauses as another name for them. Essentially, a unilateral option to litigate is where a clause specifies that there's to be arbitration as the default mechanism for the resolution of the dispute, but one of the parties will have the option to take the case to litigation. And now I'll go on to a few of the issues that the unilateral option can give rise to. And as I say here, in many jurisdictions the validity of a unilateral option clause is not recognised, or their status is at best uncertain. And what I'd like to emphasise here is we we need to look at the unilateral option to litigate and the unilateral option to arbitrate as separate here, because very different rules end up applying to them. Because if you've got a unilateral option to litigate, which you are trying to exercise, then in fact you're trying to invoke the jurisdiction of the court, and that therefore is something which is actually subject to the recast regulation. Whereas, of course, if what you're trying to do is enforce a unilateral option to arbitrate, then you're dealing with an arbitration provision, which is in fact not governed by the regulation.
So we're now going to turn to a different topic, equally complex, I fear, in relation to the regulation for European account preservation orders, that I will refer to as EPOs. And just very briefly, to provide an overview of this new regulation. This regulation provides for EU cash account freezing orders, and they're going to be available from participating member state courts from the 18th of January 2017. Now, the UK has not opted into this regulation, and Denmark has not agreed to join up. But this regulation may still be relevant to English litigants in member states, participating member states, but it may also be relevant to entities with bank accounts in member states. Now, by way of overview, the new regulation provides a single uniform court application made to the courts of participating member states. But rather controversially, this is only going to be available to litigants that are domiciled in participating member states. The regulation provides an alternative to existing preservation remedies that may be available under national member state law. Orders can be made before proceedings are initiated, during the course of proceedings, and also post-judgment. They're limited to cross-border civil and commercial proceedings, but cross-border is very widely defined in the regulation, and they do not apply. The regulation just provides that it does not apply to arbitration. There is just one little wrinkle there. It is not clear whether EPOs would be available in circumstances where an arbitral award had been converted essentially into a judgment, and you were then seeking to enforce that judgment across member states. It's very complicated legislation. There are over 50 recitals in the regulation, and with many of the provisions that you would expect to see in the operative parts of the regulation actually stored in recitals. So I think the overall complexity may give rise to quite a bit of litigation, but also quite a lot of uncertainty.